presentation, a very in-depth contribution. Now I'd like to hand over to Lukasz. Lukasz is traveled from the University of Warsaw in Poland, and Lukasz will be talking about the transformation of the Catholic Church maintenance in early modern Poland, and he will be addressing the controversies over the tithe. I'm sure you're going to elaborate on that. Is, as far as I know, a tenth of something, which of course is a very, very important concept in medieval or concerning medieval legal perspectives. He will be discussing the controversies over the tithe and the meaning of statutory law. Thank you very much. I'm going to hand this to you. Thank you.
Since the half of 16th century, the dispute between Catholic clergy and nobility about tithe has significantly increased in the Polish-Lithuanian Commonwealth. The tithe is a 1/10 part of something paid as a contribution to a religious organization, in Latin decima. The tithe is in that time in Poland there were three forms of the tithe: in cereal, in grains, and in money. The oldest form was the first. The tithe had to be given to the legitimate Catholic Church institutions, such as parishes. Disputes over the tithe between nobility and the Catholic clergy accelerated due to the expansion of the Protestant Reformation in Poland, especially the Calvinism. However, that controversies were not new for the Polish nobility, as they had been recurring since the 13th century when the tithe was introduced in Poland. That's why nobility concluded many settlements with the Catholic clergy from 13th to 16th centuries. They mainly concerned a form of the tithe and also lands that was subjected to this benefit. The Polish Parliament's Sejm's Act from the year 1543 stand that disputes over the tithe should adjudicate the ecclesial courts. Furthermore, these judgments of ecclesial courts were enforced by the secular officials of the crown, called in Polish starosta, in Latin capitaneus. Nevertheless, in the beginning of 7th decade of the 16th century, Sejm's Act suspended that way of enforcement only for a few years, but this situation continued to exist until the end of the Commonwealth. The aim of the Protestant nobility was to exclude the possibility of execution as well. Not only the Protestant nobility withheld the tithe, but also did Catholics so. Unfortunately, the extent of these occurrences has not been examined yet. Many difficulties arose in this situation, especially according to the jurisdiction. Judgments of the ecclesial courts lost the enforcement, and the clergy had to sue the nobility to their courts. However, it was a nobility's aim, as the nobles were of the opinion that ecclesial courts favored clergymen. This question also hasn't been examined yet, unfortunately. My survey indicates that the court in diocese of Lutsk, now in West Ukraine, did not always sympathize with all grievances against the noblemen. Nevertheless, the hopes of nobility were premature, because the clergy started to get them to the nobility's courts from the end of 7th decade of the 16th century. Since then, nobility wanted to conclude a general settlement with the clergy. In 1578, there was created a new Supreme Court of Appeal for the nobility called the Crown Tribunal, in Polish Trybunał Koronny, in Latin Judicium Ordinarium Generale Tribunalis Regni. A part of it was a special court consisted of 12 judges, 6 from the nobility and 6 from the Catholic clergy. It adjudicated disputes over the property of the Catholic Church. However, this same act validated the actual situation of the tithe. As a result, noblemen who did not give tithes was not obliged to do so by any court before the already mentioned general settlement occurred. Obviously, when he gave the tithe, he still had to do it. All actual cases about them in nobility's courts had to be suspended until the settlement would be concluded. Unfortunately, this act wasn't distinct and raised some new questions which were explained by the tribunal, because in practice it took the place of old legitimate courts of appeal. According to law, the tribunal wasn't legitimate to judge such cases. Soon, the Sejm Act from 1581 suspended the enforcement of the tribunal judgments that it had passed in controversies over the tithe, of course until the mentioned settlement would be concluded. This extraordinary situation was challengeable for the parish clergy with maid a living mainly from the tithe. Similar acts were issued by the Sejm several times again. Apart from the Sejm's acts, noblemen still lost in cases about the tithe exactly in the nobility's courts. My survey that concerned only one parish church in the diocese of Łódź from 1550 to 1655 indicates that the parish priest won constantly. His opponents didn't lodge a request for a suspension. The starosta enforced all judgment without any doubt, and the appellations in that cases were admitted by the Crown Tribunal. It has to be mentioned that the judges in nobility's courts and in the tribunal were noblemen, which were elected by the nobility. These people were able to judge against the opinion of his own estate. Therefore, the nobility in dispositions for the members of parliaments before the Sejms raised the questions of essential general settlement with the clergy, but it was just concluded in 1635. The Sejm established the rules for changing the tithe from the cereal to the money. He indicated also that a legitimate court of appeal is the Crown Tribunal. As we can see, the legal practice through many years disagreed with the statutory law. Moreover, new acts of parliament were prepared to destroy the distortions weren't effective. However, in the 1619, when some judges of the tribunal strongly disagreed with accepting the cases about the tithe, the rest of the tribunal decided that they had to wreak justice on all cases and the Sejm had to legislate. In my opinion, this shocking stance of the judges, which ignored the statutory law, come from the common sense. From the 1550, the disputes over the tithe had been replicated, and the decrease of the population of Protestants didn't change the situation. The statutory law was disappointing. There were acts of foundations, many parish churches that indicated the landowners which had to give the tithe. There was also an act that stipulated the ecclesial courts all disputes over the tithe, but the judgment of them existed without any state enforcement. The parish priest who sued the nobleman to the nobility's court also until the 1578 couldn't appeal to the Crown Tribunal and couldn't gamble on enforcement according to the statutory law. In legal practice, these problems were solved also with some legal devices. The nobility, as far as I'm concerned, didn't create the coherent plan for the living the Catholic clergy which had some lands and tithes. Noblemen wanted primarily to change the tithe from the cereal to the money. We must take into consideration the fact that in the 16th and 17th century, rye and wheat were the Commonwealth's basic exports. Its cost went up especially in 16th century. The judges understood, I think, that the parish churches couldn't exist without the tithe. Moreover, the rejection of giving the tithe that was indicated in legitimate documents didn't fit with their sense of justice. In conclusion, the turn of the 16th century was the time when the state courts increased its jurisdiction through displacing the ecclesial courts. However, the statutory law didn't create the change. It could occur by the legal practice because the statutory law was unclear, ineffective, and created as a reaction to the court's activity. The nobility's aspirations were got on in 1635, and they were signified by the Act of Parliament. Before this moment, only the legal practice was used in many political fights on the Parliament. Obviously, all these problems need more detailed and subsequent research, which I am going to continue. Thank you.